hopefully, we are just trying to bring, we are advocating with the respective stakeholders to introduce the clause in the agreements when they enter into even international agreements related to mediation, so that the issues could be resolved between the parties in the event, if any, through mediation is a very cost-effective manner, which is the cost factor is something which we are paying much attention to. So thank you very much for the Mediators Forum and the Lawyers Guild of Bangladesh, and my friend Dr. George Victor, for extending an invitation to share some thoughts on this very timely topic of the involvement or an evolution of mediation instead of the usual litigation, the court litigation in our jurisdictions. Thank you, Your Lordships, for the patience hearing and for all the participants, and I hope that I have shared something with you, and certainly I'm looking forward to join with you in future, so that I will hopefully share some more thoughts on this subject at your request. Thank you very much.
Thank you, Mr. Oshandra Nabaratna. In that time, I requested to Dr. George Jesu Victor to share something about evolution of mediation at this event. Dr. George Jesu Victor.
Thank you very much. The chief guest for today's workshop, Your Lordship, Honorable Justice Ahmed Sohel, Supreme Court of Bangladesh. The president of today's workshop, Your Lordship, Honorable Justice Retired Mohammed Azad. The organizers, Bangladesh Mediators Forum and Lawyers Guild Bangladesh Supreme Court. Ladies and gentlemen, participants and others, good morning. Today I'm happy to be here. It's after quite few months that Bangladesh International Mediation Society, Bangladesh Mediators Forum and the Supreme Court Lawyers Guild have come together to organize a seminar or a workshop on a very important topic, evaluation of mediation. Can I go ahead? In the meantime, you can start sharing the presentation.
Okay.
Yeah, thank you very much. This particular topic is of much interest because most of the workshops or conferences or even the seminars are concentrating on the types of mediation and the ethics of mediator, the rules of mediation and the Singapore Convention and so on and so forth. But going to the grassroots of where the mediation started and how it evolved into a process and a procedure of what we follow today is very important to understand. So today, in the next 30 minutes, I will be covering pockets, not in full, but pockets of evolution of mediation from different parts of the world. Before I start, I bring greetings from Haque Mediators Forum. And Haque Mediators Forum has been constituted very recently on the 1st January of 2025. And I also thank the organizers and appreciate on behalf of Haque Mediators Forum and wish you all the very best in all your endeavors. I just want to take few minutes to explain and also to give you a brief of what Haque Mediators Forum is. Can you please change the slide? The third slide. Yeah. Third slide. One more. Thank you.
MTS.
The chairman of Bangladesh International Mediation Society, BIMF, Senior Advocate Mr. Goswami sir, along with the respective chairman, president, member of SAARC National Mediators Forum, that's Bangladesh, Bhutan, India, Maldives, Nepal, Pakistan, and Sri Lanka, of the South Asian Association for Regional Cooperation, SAARC, nations, and other mediation forum, societies, institute, and organizations from developing and other nations have established SAARC Mediators Forum with the signing of proclamation agreement. And this charter agreement is resolved and approved and adopted by the respective national representatives on the 1st January of 2025. And what is the mission of SAARC, the Mediators Forum, that's SMF? Next slide, please. The vision is to strengthen regional peace, have cooperation, and have a mutual, meaningful, peaceful conflict resolution across SAARC, non-SAARC countries and developing nations by empowering mediators through collaboration, knowledge sharing, and cultural sensitive practices, fostering sustainable solutions for intra-regional disputes and promoting mutual understanding and trust among SAARC Mediators Forum members. This is the vision of SAARC Mediators Forum, and that's exactly on what we are working for. And I thank my previous speaker for setting the tone and also for setting the prelude of today's workshop context. And what is the mission of SAARC Mediators Forum? The mission is to promote peace, mutual understanding, and sustainable, next slide please, and sustainable conflict resolution by fostering dialogue, strengthening mediation capacity, and building collaborative framework among SAARC, non-SAARC, and developing nations. The forum also aims to uphold justice, human rights, and regional cooperation through cultural, sensitive, and impartial mediation process. This is the vision and mission of SAARC Mediators Forum, and based on very fundamental and based on very solid ground, the SAARC Mediators Forum has evolved, and we will be able to join all the mediators from the SAARC nations and non-SAARC nations and developing nations to build a meaningful mediators forum to exchange knowledge and also to exchange, to uphold justice, human rights, and regional cooperation. So let me come to the topic, evolution of mediation. So why do we talk about mediation when we have litigation, when we have courts, when we have other systems to address conflicts or to address disputes? Earlier slide, please. Earlier slide, 2 slides before. No, equal and opposite reaction. Yes, thank you. Conflict is an inborn quality, or it's an inborn twin of the human being. Without conflict, there is no human being. A human being can be happy, a human being can be sad, a human being can have different mood swings, a human being can have different, can exhibit with different moods in different environments and in different situations. But to consolidate the entire moods, we have only two. One is equal and opposite reaction. When you are happy, we treat everyone equal. We have equality. We share everything with everyone, with our neighbors. But when there is an opposite reaction, when the conflict creeps in, our equality diminishes and the conflict starts building up. And that's where our life is also. Mediation is as old as the human civilization. When human is born, the conflict also was born and mediation was also born. So these are the three important triangles when the human civilization, the conflict and the resolution or the mediation. Next slide please. So conflicts can be small and it can be as big as a war. It can be a small conflict between the siblings, the small conflict between a husband and a wife, a small conflict between neighbors, and it can be as big as a conflict that leads to a war. So conflict, whether it's small or big, it's a conflict and it has to be addressed appropriately. Can we go to the next slide? Can we go to the next slide, please? Abraham Lincoln once said, discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the normal winner is often a loser at fees, expenses, cost and time. In civil jurisdiction or in civil litigation, these are the important factors. What is the fee? The expenses cover the cost and the time factor. So if we can cut short these four elements, or if you can minimize these four elements, both the parties will be the winners and no one will be a loser. That's what exactly Abraham Lincoln once said. He discouraged litigation and encouraged to have negotiation and encouraged to have compromise, which is nothing but the process of mediation. Next slide, please. So, is mediation required? I'm not going to explain the entire slide. I'm going to explain only part of the slide. The first part, what is conceptual and the imposed. Conceptual is the very basic form of mediation, whereas imposed is the form of litigation through courts. So what are the advantages? If we opt for mediation, it's informal, it's private, and it's confidential. And the parties which have disputed come together to decide their outcome. And the parties retain control over the process. And the parties can control the outcome. Whereas in the formal, imposed court proceedings, it's very formal and public, and it's adjudicative, and the neutral decides the outcome, not the parties. The parties present their pleas, but it's the neutral who decides the outcome, and the parties do not control over the process, but the courts, the acts and the rules control the process, and the time, cost and resource. As we saw in the earlier slide, compromise is much better because even the winner in the imposed scenario will be the loser because of time, cost and resources, which are more important and much important for in today's fast evolving mechanical modern life. Can you go to the next slide? What are the advantages of mediation? Should we go opt for a mediation? The advantages of mediation is the parties decide the outcome and the parties control the process and the parties decide what the outcome should be, and also they control what they want or they decide what they want. So here, what are the advantages of mediation and where does the mediation start? The mediation starts with a conflict, and a conflict is nothing but a difference between two parties. If it is not resolved, which could escalate into a disagreement, and even the disagreement is not addressed, it could escalate into a problem which will again
give rise to a dispute between the parties, which will be a conflict, potential conflict, and sometimes it might lead to violence, and violence might end up with war. And these are the different stages of mediation, and these are different stages in which how a mediator can effectively help the parties, the disputants, to come together. So if it's a difference, small difference, a negotiation between the parties will resolve. If it is a disagreement, you need an external
neutral to come in, where the mediators are appointed and conciliators accordingly. And if it is a dispute, it has to go to an arbitrator. So when it goes to an arbitrator, the parties lose the control on the system, on the procedure, whereas the neutral will impose a decision on the parties, and so on and so forth, which I'm not going to go into detail because today's topic is only on the evolution of mediation. I'm just giving you a brief introduction of what mediation is. So next slide, please. So as I already discussed with you, the mediation conflict triangle, which is there has to be a conflict, there has to be a dispute, there has to be a solution. So what does a mediator do? Mediator tries to bring all the three elements together and put it into perspective to explain to the parties to arrive at equitable solution and to arrive at a solution which is acceptable to both the parties. Next slide, please. A brief definition of a mediation. The key feature in the mediation is that disputants, that's the parties, should take part in and construct the resolution
themselves rather than have it imposed upon them, which shall be binding and legally enforceable. And today, unlike the earlier days, the mediation agreements are also enforceable by courts under the civil law, and some countries have ratified and approved the Enforcement Act, but some countries are yet to ratify and enforce the Enforcement Act. But by and large, the mediation agreement is enforceable by the courts. It's important for us to know. And who's a mediator? Next slide, please. Who's a mediator? The best and experienced mediators resolve disputes discreetly, efficiently, and most importantly with fairness to both parties. He's a neutral and he has to show fairness to both the parties, and it is always important that the mediator have to follow certain ethics, which is very, very important. So now let's go into the topic and quickly I'll finish it in the next 15 minutes. Evolution of mediation. Next slide, please. Mediation has always been a part or additional or alternative option to resolve conflict, dispute and litigation between disputants, that's the parties. So how old is a mediation procedure or the process? Mediation has been a part of human evolved with every civilization. So in the next few slides, we will see how the civilization evolved and how mediation evolved and how conflict resolution evolved. And the mediation dates back and it's as old as BC, that's before the birth of Christ. The process is based on impartiality to mediate peace, and the most important is the agreement is accepted as final and binding between the parties, because the decision of arriving at agreement is the decision of both the parties. So that is how the mediation is evolved along with the civilization of human mankind. So in the next few slides, I will be discussing only few pockets of civilization. It will be not be a very detailed one, but very important civilizations we will be discussing upon. Next slide, please. The first is the ancient Israel mediation, which many mediators take a leaf out of it to explain how mediation started. So I'm not going to be very brief because we all know this. We all must have heard in your mediation accreditation classes. So I'll be very brief on this. The first is as old as if any biblical a person with any biblical knowledge will go back to Abraham, who was the father of
both Christianity and Islam. So Abraham mediated, he not only mediated, he negotiated with God when the cities of Sodom and Gomorrah was to be destroyed. And he not only mediated for the people of Sodom and Gomorrah with God, he also negotiated. That's the first negotiation and the mediation one can date back through. And what is this negotiation? He said, if you find 50 people, will you not destroy the cities? And it came down to one. So that's an art of negotiation. And Moses for the people of Israel. That's the first community mediation we can go back and see in the history. And plus Jonathan, who mediated between King Saul and David when Saul was seeking to kill King David because of jealousy and rebellion. So that's a mediation between the family mediation, the first family mediation dated in the history. And the well-known mediator Solomon mediated for a child between two mothers. One mother's child was dead, the other mother's child was alive, and the dead mother child claimed the child to be hers, and the alive mother also claimed, the child alive mother also claimed to be hers. And it was very interesting to know how Solomon mediated between these women, and he found out who the real mother is and handed over the child to the real mother. Next slide, please. Next slide, please. And the Asian Middle East mediation, it started with Mesopotamian civilization. It was the earliest known civilization between river Tigris and Euphrates, dated 6000 to 1900 BC, which is a Sumerian society, which is a very important form of mediation from where it started. And ancient Mesopotamian civilization. Come in, sir?
Short way, please.
Yeah, I have another 5 minutes and I should be able to complete it.
Thanks, sir.
Yeah. And Sumerian civilization, the Mesopotamian civilization, where the master helped resolve disputes without court intervention. And a master is nothing but a mediator who has the qualities and ethics of the modern mediation society. Can we go to the next slide? The Chinese mediation, China has a long history of mediation under the Confucian influence from 551 to 479 BC. Mediation trumped the superiority of law, and Confucius advised that the best solution to conflicts was ethical reconciliation over legal conflict, establishing very mediation process, and even today China opts for mediation processes. Next slide, please. And Islamic law of mediation, Sharia law supports dispute resolution through mediation, and this is what I have picked up from some of the history books, which I consider to be correct. The scholars assert that during Prophet Muhammad's earlier life, tribes warring over the Kaaba reconstruction chose him as a mediator. Prophet Muhammad mediated between tribes and communities to accommodate and uphold both parties' interests. Next slide, please. And ancient Indian mediation, Mahabharata, it dates back to Mahabharata, where Krishna mediated between Pandavas and Kauravas to avoid Kurukshetra war, but his mediation failed and Kurukshetra war did happen. So as mediators, mediation will not always yield a desired solution.
Mediation may also fail. So if mediation fails between the parties, then the parties have other options to pursue. The oldest panchayat system were used to resolve disputes between parties by local councils and respected elders or the mahajans as mediators, which is widely practiced in the Asian countries like India, Pakistan, Sri Lanka, Bangladesh, Nepal, Bhutan, and other countries. Till date, panchayats and pancha parameswars as mediators between individuals or groups or some of the tribes in the Asian nations. And what is the evolution? The development of modern law and the transition and reforms from ancient law evolved sharp decline in the mediation and next slide please. In mediation negotiation and sharp increase in court litigation. With development of legal rights, individual rights, context, commercial management and cross-border disputes, the court litigation increased and the mediation and negotiation decreased. Next slide please. And the modern age mediation is attributed to the civil rights campaign followed by development to address community grievances, cross-border dispute between the nations, sharing of natural resources and increased workload of loads leading to prolonged duration for solution. So these are the factors which developed the modern mediation era. Next slide please. And the empowerment of parties. Next slide please. Mediation empowers the parties in decision making, to resolve the disputes among themselves and have the control on the outcome. Next slide please. So civil justice, the critical issues are cost, delay and complexity. In mediation, if these factors are minimized, then it will be a win-win situation for both the parties and it will also reduce the workload of the courts, which handles much more important constitutional issues. So the issues that gives rise to a conflict can be taken to a mediator, referred to a mediator, and a mediator will be in a much better position to bring both the parties to discuss and to arrive at an amicable solution rather than litigating. In the modern age, the modern era, it is more important that the parties should invoke mediation for easy cost effectiveness, for speedy justice, and to resolve and control the entire process with themselves and to coexist peacefully and harmoniously. Thank you for your patience, and if there is any questions, I can take the questions. Thank you. If there's no questions, I thank the organizers for inviting me to deliver this talk, and I thank Mr. Goswami sir also for giving me an opportunity. Thank you very much.
Thank you, sir. Thanks, sir. Simran, you complete your presentation only 10 minutes. Simran.
Thank you, sir, with the picture. Now, I requested to Ms. Simran to share her guidance speech about mediation in Nepal.
Okay, thank you so much, Fazel. And so, thankfully, we are in workshop on evolution of mediation, ADR instead of today's work. So, the chief guest of today's workshop, Honorable Justice Ahmed Sohel and Honorable Justice Muhammad Emdadul Haque Azad. Senior Advocate Ben Goswami sir, and Dr. Jers and every participants present out here. Today, basically, I would be talking on the mediation in perspective of Nepal, basically. So first of all, when it comes to our mind, like why mediation is very, very important and why are we talking on the mediation? Because you see that ADR can provide increased access to justice for citizens. And perhaps you see like for the resolution of disputes, they may not be regard themselves have like received the justice, but may simply consider that they have attained the more modest goal of settling the dispute. The mediation in the context of Nepal, we have achieved the ambition that basically this is for attaining the more modest goal of settling the disputes. So very wonderfully in the context of Nepal nowadays, mediation has been more, prolonged because in even you see like different courts and even Supreme Court of Nepal, after like every benches where the court hearing is taking place, like behind we have posted a very big banner saying that please follow mediation rather than moving on to the case and the long proceedings that might come afterwards. So this is what nowadays even the various courts, even the parties, they are moving for the perspective of mediation because this is very, very, very important. And at the same time, basically in the context of Nepal, mediation has evolved for different scopes of mediation. Talking some of them, then there are like civil and family contractual disputes, the court referred cases for mediation, and also the community level issues. And that's how the mediation in Nepal is increasing. So now, dear participants, I would like to take you back to the Ottoman eras where there used to be no courts, no community mediation, no court-referred cases, and also the no personnel for suggesting mediation. So basically, you can imagine the scenario, how can the disputes used to settle by them. So before there used to be violence, the fight and the conflict resolution was very tough because there was not the formal mechanism, and also there was not ADR. That means there is also no mediation. But later on, what happens was like people started the importance of mediation because you see there are many hajads of mediation for sure that might take too many long time, and also that's not very cost effective, as Dr. George has already explained more about the benefits of mediation. Yes, similarly in Nepal also mediation, for the perspective of mediation, we have actually analyzed and utilize the mediation for maintain and restore the relationship among the parties basically. And it is also, you see, disputes are very cost efficient. I would say it's not just only effective, but it's actually efficient because you see in mediation, the parties can control the consent of the argument, and which is the best part. And I would like to repeat this point because this is very important because in Bangladesh also and Sri Lanka, as in India, Dr. Joel has already mentioned that this is one of the best fruit for the mediation because parties themselves can control the consent of the agreement, and also the mediator, they manages the process, and the best part is mediation is more confidential, and also the best prospect is impartial for sure, and that's how you see that can create peaceful communities in Nepal, and we are actually advocating for mediation, and even in strategic plan we have perceptions about mediation. I think not only in Nepal but in Asia Pacific there is some false perception about mediation because they think that mediation is only suited for the small disputes. They don't believe that okay, for larger disputes, for company disputes, mediation is not suitable. But actually, what happens is like in Nepal, mediation is also suitable for the small disputes. So that is what we must remember. And also, for example, another false perception that we have in Nepal and also in other Asia Pacific is that there is no place for lawyers in mediation. That's completely false because lawyers can also be the mediators. In fact, lawyers can be the best mediators. So that is why there are some legal advisors. They have certain misconception about the mediation that I want to clarify, and that is, like some things that legal advisors are unfamiliar with the mediation, which is not true, because in Nepal, what we have practiced is that while framing so many contracts, we have kept the clause where first solution for the settlement of the dispute is mediation. So now another false perception that I want to highlight, because we have very limited time, so I just talk on the last one, false perception about the mediation in the context of Nepal, is that lawyers basically perceive that if we move on to the mediation, then there will be the loss of income. So there will not be the income source, so we have to move on to the case so that we can generate the income. But that's really false. Because you see, though it is cost effective, you can generate income by taking so many mediation cases, isn't it? So that is why we must understand this important perspective of mediation. Having said this, I say that mediation is very efficient process for a dispute settlement mechanism. But there is also certain criteria, certain qualifications for the mediators to be the mediator in the context of Nepal. The mediators training. So mediators training is one of the most important thing. And one of the recent articles that Harvard University had just published is with regards to this mediation training. That means mediation training must be completed. One, random people who do not know about mediation, who do not know about the techniques and the procedures of mediation, is not capable for taking part of the mediation. So that is why there are certain, qualifications for the mediators. And also we have mediation council in the context of Nepal. In Bangladesh also we have different mediation council. And also BIMF is also advocating for mediation. Similarly in Nepal, we have registered mediators, and they are actually trained, and we have also the mediation council. And that's what is the most important part, is that mediators qualified to be qualified, they must be very impartial and neutral. If they are biased, if they, they want favoritism and representation, that's not entertained in the context of Nepal. So this is the most important things that I want to talk about. And also, all the participants out here, I want to clarify some of the important topics for today, as we are having the workshop on evolution of mediation. So focusing on the ADR instead of village courts, right? So we need to encourage the process of mediation. And like the role of mediators, as I see in the participants also, there are many trained mediators out there. So we must need to know the important role of mediators. So in Nepal also, we have formulated one important framework, and we have also different legal frameworks working on, which I will be talking on. So first thing is the facilitation of dialogues. So what we are actually doing is in Nepal, while giving the training to the mediators, upcoming mediators, we are basically focusing on giving them the training that can actually develop the skills for facilitating the dialogue between the parties. Because disputing parties are already there in conflict. We must remember that, because they are not in peaceful state. So conflicting situation is there, so the most important part is the facilitation of dialogue. So that means you need to help with clarifying the issues to both the parties, and also you need to remain neutral, and that's the most important thing. And I'm repeating it time and again, because as I already stated that recently in the even in the New York Journal and Harvard University Journal published, they are actually prioritizing on neutrality and the prospects of impartiality for the mediation. So now, give me some few minutes, so let me allow to talk about some important legal frameworks in the context of Nepal that we are diving in. The first one is the Mediation Act, 2068. And so now I'll just take 5 minutes to complete what is there in the Mediation Act. So basically, if you see the sections out there, from section 4 to 23, we have different important prospects with regards to the mediation and the important prospects of mediation in the context of Nepal. The first one is the section 4 talks about the voluntary process. So we do not confine, we do not mandate the parties to please come up and mediation, it's mandatory. We do not do that. But what we do is we actually, in Nepal, what we do is we actually highlight the importance of mediation, the goodwill of mediation, the benefits of mediation. So that's what we do. So that's simply a voluntary process. If the parties wants to follow the mediation process, and that's the best part that we get to. And the second one is sometimes court-referred for mediation, and that provision is actually highlighted in Section 6 of the Mediation Act in the context of Nepal. And regarding the mediator's appointment, I already talked before as well, but typically talking as per the article, then we have this Section 9 of the Mediation Act, which talk about this mediator appointment. And the important framework that I already stated is with regards to the different principles that underline the mediation itself. And that the first one is the Section 16 talks about the principle of confidentiality. And the principle of confidentiality is very important. That's how we can link it with trustworthy precedents. So that is what is very, very important. And the most important part while talking about mediation is the Section 18 actually talks about the mediation agreement. So we frame the mediation agreement and we make sure that both the parties have their issues already settled there in the agreement, and we proceed with the legal status, which we are delving on in the Section 20 of Mediation Act of Nepal. We have also certain code of conduct that mediators must follow with regards to mediation. So now, for the last minute, I will be talking on the Mediation Council, like how Mediation Council is, regulating and training the mediators. The first one is maintenance of register. Why this is important is that the special framework for mediators and the number of mediators that we have, not only the mediators, I would say the trained mediators. So the list of trained mediators is also very, very important, so we are maintaining the register for that. And this is actually important for promoting the ethical practices. So as the first speaker of today has also talked about the importance of mediation, and also he has a little bit touched on this community mediation as well. In the context of Nepal, being very brief, the important framework for this is regarding community mediation is used for local and rural disputes, and they are handled by the local centers, and sometimes it is being supported by NGOs as well. So these are the things that the context of mediation, and in the context we are following this kind of frameworks. And also, if you want more details on how mediation is taking place and how the court itself, how Supreme Court itself is highlighting on the mediation part, then you can simply contact me. I can help you out with what are the important frameworks for the mediation in the context of Nepal. So as we are running out of time, lastly, what I want to say is that mediation, it's very important, and mediation is also backed up by different international framework. So if you talk about Bangladesh, if you talk about Sri Lanka, and the India, and the Hong Kong, China, and all the Asia Pacific, we have been guided with this UNCITRAL model law on international commercial mediation. So I would like to, I would like you to take a note on that, because you might then after this presentation, you can simply go on to the UNCITRAL model on international commercial mediation, because basically this is flourishing even in Bangladesh, even in Nepal. So you can have the overview of how this UNCITRAL model law on international commercial mediation is actually flourishing, how is it working in different countries like South Asia and Asia Pacific. So after the presentation, you can simply download that file and see the current mechanism, that how mediation is actually mobilizing, how it is functioning, and how it is actually moving forward. And also, as Dr. George has highlighted a little bit on Singapore Convention, but what I want to say at last is that please also look up on this Singapore Convention on Mediation, because this has the highest prospects of that I already highlighted, the importance, the actual thematic prospects of mediation and why it is increasing. So that's all that I want to tell about the mediation in the perspective of Nepal, and I think we are right on time. So thank you so much for this opportunity, the organizers and everyone. So now we have last 3 minutes, so if anybody has a question with regards to the mediation practice or anything with regards to the prospects of Nepal, then I would like to open the floor for the questions. Thank you. If there is any. So you can simply write the question. Yes, yes, sir.
Any question?
Any questions? If not, no questions. So do we have time? Shall I move forward or shall I end here?
Yes, up to 3 minutes. More
After
2 minutes. More 2 minutes.
Okay, then I have 2 minutes. Then definitely I will be talking on the important derivation of the mediation program. Then, you know, in the context of Nepal, while designing a certification program, we have actually come across with the balancing approach, and we have talked about it as a balancing process where many values are implicated, and the need to provide the participants to prove with the quality mediation services, and also to maintain the diversity in mediation with the unique techniques that the mediator background has, and also the need to shape appropriately the direction of a rapidly evolving field. And also the important thing is, as I was just given 10 minutes, though I want to highlight something on this important prospect, the modern approach on this mediation in the context of Nepal is that the balancing the interest phenomenon, and which is the important values, and it's really a daunting task, but fearing that appropriate balance cannot be achieved by a certification program. But however, the failure to attempt to develop certification cannot be only applicants the mediation community's responsibility for participants. So somehow balancing this interest, we might miss a valuable opportunity to steer the growth of the mediation field in the direction of, ever increasing quality and innovation. And so that is why we are actually. It's 11:30. So I think the time is over. But summing up, the development standards have been developed. So I think mediation and community mediation, the administration of the mediation certification system is going on, and we are actually moving on for this. Thank you so much, everyone, for your patience listening, and I hope to. And I also wish you all the best for your workshop, and thank you so much for joining. Thank you.
Thank you, Simran Nafi. Now I requested to Ms. Joshua Alvora to share mediation in our work.
Good morning, everyone. Can you hear me well? Okay.
Audible.
Okay, great. First of all, good morning, everyone. Evening, please. So happy to be again here with you. I'm Joshua Hasbuna. I'm a mediator. I was there because mediation and our work, and including the history, culture, and its data. So first, let me share my screen with everyone so you can see exactly what I'm doing.
Yes, sir.
Please. So again, good morning, and I'm glad to be here with you everyone again. It's been nice to be again with you this time. So for my presentation, I'll be talking about the mediation or the history of mediation in the report. We're talking about four main issues. Beginning, we will talk about what is the definition of mediation, what is the main characteristic of this process, especially in general, and which also is applied in our report. Next, then we will go to the historical and cultural root of mediation in our report. We're talking about three main era: before Islam, during Islam, and after this process. Then we're talking about the exact and the role of mediation in the religious and traditional Arab society. Because when we're talking about the Arab society, we're talking about three main levels: the religious level, the traditional and custom level, and we also have the final one, the legal or the official levels. This we'll talk about in the last section of this presentation. We're talking about the implication of legal of mediation within the legal different laws and legislation in the Arab countries. So, to begin with, when we talk about mediation, what do we mean with mediation? In general, mediation is a voluntary, non-binding, and confidential process in which a neutral third party, who called the mediator, help disputing parties to reach a mutual acceptance and agreement between them. So, we're talking about three main characteristics when we talk about mediation. First, it's a voluntary process, which means there's no pressure on anyone to join the mediation process. You have the parties need to enter this process by themselves with a full will. Confidential and neutral process. Confidential means that everything that happens within the mediation process must be kept secret and confidential between the parties and the mediator. Hence, even if the mediation process, especially the non-official mediation process, failed, anything that has been said during this process cannot be taken or considered if the two parties reach the official courts. And finally, it's a neutral process, which means that the mediator, the person who is facilitating the process between the two parties, is a neutral one. He does not have any benefit from either of them, because and if in case he has any kind of benefits or interest that come from one party or the other one, then the whole process can be considered neutral. Secondly, there is a third party in the mediation process. The main idea of the mediation is that we have to have a third party. This person usually have either on the local level. He either have a good reputation. He is one of the community elder, maybe the religious leader, the tribes leader, or he is a person with a great and highly respected personality and position in the society. The role of this party is to facilitate the whole process between the conflict parties, and help them to actually see what is the problem and the issues between them, help them reach a solution that can reach a solution and agreement to their conflicts. Finally, it's a mutual process, which means that the final solution that the two parties will reach in the end of the process is accepted by the two parties, which means we cannot actually impose any kind of solution on one party or on the other. And we cannot reach an agreement that one party accepts and the other party see as not fit for him. The main cases is we need to reach and accept a mutual acceptable agreement between the two parties. This is what we mean when we talk about the mediation. This process has several core characteristics. First, as we said before, it's a voluntary participation, which means the parties have the right to enter and also to exit the mediation process with all their free will. You cannot pressure anyone or proceed anyone to actually participate in this process, or prevent them from leaving this process when they see it as not good fit for their problems. Finally, secondly, the mediator is a neutral one. As we said, the mediator must be impartial one. He shall not have any conflict of interest between him and the two conflict party, and he must respect the wish of the two one. Confidential process. As we said, everything that is said in this process is confidential, which means that if the process failed during the mediation process, nothing that happens in there should be taken to the court or considered in the court. So if one of the parties confess their guilt during the mediation process, this confession cannot be considered in the legal process in the court. If a party didn't solution, one of the main characteristics of mediation is that the two parties actually reach a solution themselves. The goal of the mediator in this process is not giving them the solution. It's helping them to actually reach the solution that they see fit and acceptable for both sides. And this makes the mediation differ from several other practices within the Arab world, such as arbitration or judicial process. Because, for example, in arbitration, the arbitrator, he gives the two parties the solution. However, in the mediation, the mediator helps the two parties to reach what the best solution for them, not impose any other solution on them. Finally, it's a restorative and relationship-focused process. What makes mediation a very interesting and helpful practice is that it's focused on the relationship of the people. It aims to actually restore the broken relationship that happened because of the conflict between these two parties. Hence, it's focused on restoring this relationship, repair the harm that has been done between to the two parties because of the conflict that happened between them, and this help restore their relationship in the future and stop the blame and the violence circle among them. So they won't keep focusing on the harm they have done to each other. They will work on fixing this issue, fixing their relationship, so they can just get over this page of their life and start a new chapter with a good and fresh perspective about themselves. So this is the main characteristic for the mediation. So in the Arab world, the mediation in the Arab world, we talk about three main historical era. The first one is mediation in pre-Islamic Arabia. The Arab society is a tribal society, which means that there was many practices that focus on mediations or used at least mediation in their daily process. For example, the main practices that have been used very much in the Arab countries, especially the tribal Arab countries, is the conciliation, which we call in Arabic Sohel. The reconciliation is a process that it used several practices such as mediation and arbitration. It aims to resolve the conflict between the two parties, whether they were individual, communities, tribes, or even countries. The main aim is to resolve the conflict, set a specific reparation and compensation for the damaged party, and fix and restore the relationship between both parties. Another example or practice that has been used within the Arab countries before pre-Islam is the Jaha system. This system is, let's say, there was a conflict between two parties, and the offender. So the offender will go to the tribe elders or the tribe leaders and ask them to create like a group of them. So this group will go to the victims' houses and ask them to engage in a reconciliation or mediation process with the offender. The main aim of this system is that when the elders and tribe leaders actually engage in this process, it gives the victim the sense that they are important, they are respected, and their wishes and the harm they have been done to them is recognized by all the parties. So this system also is part of the mediation process because the whole aim of this system is to start the mediation process between the two parties. Finally, what makes the mediation a very important aspect of the pre-Islamic Arabian tribal system is that the focus of mediation or restoring and preparing relationship between the conflict parties, and the aim to compensate them and restore, let's say, harmony and peace between them is the main aim of the tribal system itself. The main aim of the tribe is to keep the social harmony among its members. And when using mediation, the tribes try to
resolve any kind of conflict between its party or between the tribe themselves to keep the system peaceful and harmony between everyone, and avoid any kind of further conflict that can actually result in weakening the tribe itself. Because if you have a weak tribe, you will not have a safe environment for its people. So maintaining the tribal's harmony and peaceful situation help very much in empowering these and strengthening these tribes within a very harsh environment that depends on how much the tribe is powerful in this country. So the second, let's say, era is the Islamic era. The Islam have started in the Arab world after the Prophet Muhammad. So the mediation and these practices have mentioned firstly in the Quran. The Quran supports the use of mediations and peaceful practices to resolve conflict, as it was used in Hujurat, it would say, if two parties among the believers fall into a quarrel, make peace between them. So, making the peace and resolving the conflict peacefully between the two parties is one of the main ideas that need to be taken, the first step that need to be taken according to the Quran. Another thing that Prophet Muhammad also frequently have played the role of mediator between within several conflicts, whether it was between tribes or between individuals. This role also have strengthened the idea of that mediator is a person that is respected, that have a high position, and a respect from everyone around him. Another thing, as we said, reconciliation or sulh, which is a very important and basic practice within the Arabic culture, Arab religion. And using reconciliation to resolve conflict is not only, let's say, unexpected or unusual. It is the main or first step that should be taken within all types of conflicts, whether it was criminal conflict, financial conflict, personal conflict, all. So another thing, it was mediation, or it was also assisted within the economic jurisprudence. This type of jurisprudence was to recognize that reconciliation is a very legal mechanism within several types of conflicts, such as civil and family matters. In addition to that, reconciliation where it's not under economic law, if they could have not contract Sharia, it would say that if the source, if the reconciliation that is being used is using or stimulating, say, unacceptable to either economic religion, this type of reconciliation is not acceptable. The actually reconciliation in conflict should be in accordance with the Islamic law. We talk about the mediation in the Arab culture. The Arab society, as I said, is a tribal law, a tribal society. It's focused on the family as the main core of the society. Furthermore, the family as a main core, there was also two several things: the honor of the family and the tribes and the community, and the social cohesion among all of these. The way to actually keep the social cohesion and keep the honor of the family is using several tools to resolve conflict and take the and save or protect the victims' rights using mediation in this case. Also, the elders in the Arab world is a very important position. So you will find tribe elders, you will find community leaders, you will find religious leaders. All of these figures play a key role in resolving conflict, whether that was using mediation, using arbitration, or other kind of practices in the Arab world. So the respect these people have in the community make it much easier for them to actually engage in the mediation process and be sure that whatever decision they will reach in the end, the whole society will accept and will implement it. Another thing is, mediation is not uncommon practices. Even if there was two children who play in the garden, fight with each other, the first step the family will take is using mediation and reconciliation just to solve the small dispute. At the same time, when we talk about conflict between two countries,
Also, mediation is one of the main practices that is used to resolve this kind of mediation, this kind of conflict, whether it was commercial, political, or even military conflict dispute in many cases. So another important issue, thing to why the Arab culture and Arab family and laws use mediation and reconciliation frequently. It's the issue is preventing any escalation of the conflict.
So usually there is a conflict between two people. It is not at this drive from the beginning. The conflict will keep escalating, and the one crime that happened, whether for example, will become another second and third and fourth time. This is what we call prevention in Arab countries, which is a very common practice. That when someone is killed, for example, the victim's family will try to make revenge for the offender family and kill another person and keep going. This issue will keep the dialogue going on and on, and the relationship to be more destroyed and the social harmony to be either further destroyed. So, mediation is a tool that's used to prevent any type of escalation. So, once the crime is happened, and once the mediation will start, any escalation will be prevented. No one is allowed to actually commit any type of revenge action against anybody. This will give the mediation the person the chance to actually resolve the conflict, help the two people or the two parties to reach an acceptable solution for all of them, and stop any kind of violent escalation or committing any more crimes. This will help not only protect the conflict parties, but it will also help protect the community itself. Because in many cases where the conflict has escalated and the violence spread, it was not only the two parties who actually were affected by the conflict or the violence, but it was the whole community. Many people were lost their lives, they were injured, lost their houses, and it gets all the more to crush the whole system. So mediation is helped in actually prevent the escalation and keep the damage to its people. We talk later finally about the legal and constitutional for mediation countries. Let's say that the importance of mediation on the social level or the religious level has brought many Arab legislators to actually adopt these practices into their own legislation. For example, we talk about mediation or reconciliation, many countries have adopted these practices into their law, whether it was criminal law, civil law, or personal statute law. For example, in Georgia, when we talk about mediation, there is a mediation law 2016 to license mediation system. In addition to this one, it's especially for civil and commercial cases, for example. But at the same time, in Georgia, we're talking about the juvenile law within the criminal system. The juvenile law has said that mediation is one of the main tools that should be used in additional juvenile crimes before it goes to the courts. So it is used in both civil and criminal system. Also in Palestine, use reconciliation and mediation with several laws. For example, in family courts and personal statute laws, mediation is the first step that should be taken in case of any type of dispute, whether it was divorce, marriage conflict, or children cases. Mediation is the first step, as it would say, the first step that should be taken, and it is made by the personal statute that is in the court. In addition, there is also a use for mediation within the juvenile law, which consider mediation as a main practice that should be taken by the prosecution office to assist the juvenile crimes and offenses. In Egypt, for also, mediation is used in personal statute cases. In general, all the Arab countries, when we talk about the personal statute laws, actually use mediation as reconciliation. Because as we said, the personal statute laws deal with a very specific and sensitive issue. It's family issues, husband first issues, children cases.
So the main idea of using mediation and reconciliation in this type of issue is to keep the family safe, keep the family within the visible touch of the judicial system, because the Arab countries believe that using these type of practices instead of going to the court will actually help the families to resolve the conflict better and keep the relationship much better between the two partners, because the husband and the wife. Because if these families went to the court and faced the civil and the personal statute laws, that will result in fixing in a bad way the relationship between the husband and the wife. Which means that even if they resolve the conflict in the court, they will not return to how they were before they go to the court. Which results affect the dignity of the family, children, the children, and the total community. In addition, we talk about UAE, the people. Using mediation and reconciliation is a very common way, which can help actually lessen the pressure of the official judicial system, because we're talking about huge and vast number of cases in every day. Using mediation can help lessen this number of cases that the judges see every day, and at the same time it helps the people to reach solutions out of the courts in maybe a faster time, because in many cases the judicial system in many countries, for example in Palestine, in Egypt, in Jordan, the court takes a long time to actually reach a solution to the case. It can take, for example, from 1 month, 2 months to 10 years or maybe 15 years, especially for big cases like the land cases or even financial cases. So in this situation, many people prefer going to the mediation and to the reconciliation process to save time, save money in many cases, and reach the solution that is fit for their own problems and the expectations, instead of just waiting in the court for something they may not compensate. Finally, we're talking about Morocco. Morocco used the mediation and reconciliation process into their civil procedure code. When we talk about the legal system, we talk about two types: the procedure law and the normal law. The procedure law, in many cases, whether it was civil or was criminal, they usually use mediation and reconciliation to help fasten the judicial process, to lessen the pressure on the legal system, and to give all the chance to actually reach their solution in a better way. So this is how the legal recognition, the strength, let's say, position of reconciliation and mediation on the ground reflected on how the Arab legislators have adopted this kind of process and practices into their official system. And now many prefer actually to go into a mediation process or reconciliation process that is unofficial, outside of the court, instead of going into the court and wait for maybe years and spend so much money to reach a solution they may not actually be fit for them. However, it is a very useful practices. It is used very widely. However, there is several and many challenges to actually institutionalize these practices within the Arab system. Although there is many laws that adopt mediation and reconciliation, but these laws are still limited compared to the huge number of laws, legislation, and cases and issues that facing the Arab citizen every single day. So there is a need for more regulation, more legislation to be enacted in order to deeply and more broadly use and adapt these practices. Furthermore, in several countries, there is a lack of training about what is mediation, how it can be done, what is the practices, what is the best practices of mediation, how other countries and experience are working with this kind of mediation practices. So there is a need in many countries to create a training centers, training stations, bring training expert to actually training people in the judicial system on how to use mediation and how to enact or encourage people to engage in this kind of practices instead of going to the official system. But furthermore, there is a resistance from the legal professionals. Going to the mediation and the reconciliation means that many lawyers, let's say, basically, will lose their not lose, well, their job will be affected negatively. Because if there is no people in the courts, the lawyers, let's say, will not have the same level of work and income as before. So many legal professionals and bar association can see the use and the institutionalization of mediation and reconciliation at the official level as a threat to their livelihood, to their income, and to their professional and future work. So there should be a dialogue between the legal professionals associations and the Minister of Justice and Minister of Justice in the many Arab countries to reach an acceptable solution and the ground between the two parties to actually use and adapt these practices within the legal system. Finally, there is a need to standardize framework and awareness. Although many peoples and a huge number of people of the Arab world use mediation and reconciliation, there is still a need to standardize the framework of these practices within the legal system. Because what is happening on the ground in some cases is different from what is happening on the official level. So there is a need from a work from the official level to actually standardize and spread more awareness about what is real mediation is, what reconciliation is really is among the public people. Okay, finally, I know I have talked for a long time, so finally I will conclude in here. Mediation, as we said, in Arab world is a historic practice that has been used for a long time, and it's still being used at a more, let's say, legal and official level at the time being. It was affected by two main aspects: the customs and traditions of the Arab world, and the Islamic teachings that reinforce these practices and its importance. The legal system were also aiming and working on formalizing these traditions, the reconciliation and the mediation within its legislation in order to make it much easier on both the official legal system and the individuals themselves. Finally, mediation is a very powerful tool that can be actually not used to only resolve conflict, but as I said, it's a tool that can help restore relationship and repair the damage that has been done between for all the people, and in the end reaching peace, social peace situation and social harmony. So it is very important to actually formalize these practices and for the Arab countries and they want to use it in a more official and practical way to make it more efficient and more helpful. So finally, thank you everyone. If anyone have any question, you can ask for me, and I would be also glad to give the presentations to anyone who need it. So thank you again, and I hope you are very good and helpful work.
Thank you. Now, I would like to request Mr. Emdadul Islam, Advocate and Mediator, President Mediators Forum, to give his valuable speech about mediation in Bangladesh. Mr. Emdadul Islam.
আমি কিভাবে দেখাবো আপনাদের এখানে দেখা মেশটা দিয়ে দেব প্রজেক্টর দেখাতে হবে তো এখানে এই স্ক্রিন বন্ধ করতে হবে
Very good, Today's chair, Justice Emdadul Haque, Azad, and respected guests, and of course, the Mediators Club in this house. Very welcome on behalf of Bangladesh Mediators Forum. As the President, I am just organized for a few words for today on behalf of our forum. Thank you very much for this delighted session. we have enjoyed very fantastic speakers over the world, especially Mr. Dr. Gada and also Simran Napeed from Nepal. She is a very rising mediator in Nepal. And especially she is trained by the BIMF in Bangladesh. Why mediators? Why mediation is important? Because I want to show a simple slide, like a 5 taka note, that will give a good, clear answer to all of us. Just like a 5 taka note. Bangla 5 টাকার নোটের চেয়ে আর কম টাকা আছে? 2 টাকা 1 টাকা। 2 টাকা 1 টাকা। 200 বছর আগে তো কোনো কোর্ট ছিল না, ছিল? আমরা এখানে যারা আছি ছিল না। Eliza Impey, the first chief justice in this British colony, William Ford যখন পোস্টে নামে, তার আগে তো কেউ চিফ জাস্টিস বা জাস্টিস ছিল না, কিন্তু কনফ্লিক্ট রেজলিউশন হইতো তো, কনফ্লিক্ট ছিল,
এটা করে দিতে হবে হচ্ছে
ডিসপিউট ছিল, বাট হাউ those solve? একটু দেখা যাচ্ছে এই যে একটা ভেরি রিসেন্ট নিউজ পেপার থেকে আমি কালেক্ট করেছি, ধরেন 1 মাস আগে। কোটি মানুষের দেশে 45 লক্ষ মামলা পেন্ডিং, এবং এইটা কমছে না, বাড়ছে every day. This is a very danger of our peaceful society. Making a peaceful society is a very dangerous phenomenon. Okay, thank you. You can keep it there. Okay. আমার স্লাইড নাই, আমি জাস্ট কিছু নোট করেছি, এটা আমাদের ইয়ের জন্য, এটা হয়তো এডিটেড করে আবার আমাদের ফোরামে থাকবে, ওয়েবসাইটেও থাকবে, সবার অ্যাক্সেস। নো কপিরাইটস। মেডিয়েশন একটু চিন্তা করে দেখো, এটা কি একটা ব্যক্তির কাজ? এটা একটা পরিবারের কাজ? এটা একটা বস্তুর কাজ? তাহলে এটা কি? মেডিয়েশন বাংলাটা কি? মধ্যস্থতা। আমরা সবাই যেহেতু আইন অঙ্গনের লোক এবং সামাজিক কর্মকাণ্ডের সাথে জড়িত, এটা মধ্যস্থতা করে। আমরা হিস্ট্রিতে দেখেছি সুলাইমানি গল্প এবং আদার্স, যারা প্রায় 6000 বছর আগে যে মেডিয়েশন, সেটা কিভাবে করেছে? টু অ্যাড্রেস দ্য পার্সন। কোন পার্সন? যে কনফ্লিক্ট যেখানে রেজ হয়েছে, যারা পার্টি, যে মেডিয়েটর, তার প্রমাণ করতে হবে যে আমি কনফ্লিক্টে। আমাদের যে ট্র্যাডিশনাল কোর্ট সিস্টেম, সেখানে কি এটা করার সুযোগ আছে? If my opinion is very limited. In mediation, no judge, no decision. Very plain and simple. আমাদের বাংলাদেশের যদি শান্তি আনতে চাই আমরা পরিবারে, কমিউনিটিতে, তাহলে আমাদের মেডিয়েশনের কোনো বিকল্প নাই। অনেকে আমরা যারা মেডিয়েশন ট্রেনিং নিয়েছি বলেছি যে ADR is a part of mediation, right? It's a basket, it's ADR, there is a arbitration, negotiation, conciliation, mediation, right? Only mediation, there is essence, that is the value, volunteer. আর সব জায়গাতেই কিন্তু আপনার একটা ইম্পোজিং আছে, ইনফোর্সিং আছে, একমাত্র মেডিয়েশনে নাই। যার কারণে আমেরিকাতে এবং ইউরোপে, অস্ট্রেলিয়াতে এটা খুব পপুলার। কারণ প্রবলেমটা তো কোর্টের না, প্রবলেমটা কার? ব্যক্তির বা পরিবারের। একটা চিন্তা করে দেখেন, বাংলাদেশের কোর্টে যে আমাদের যে আর্টিকেল আছে রিট জুরিডিকশন, পঞ্চগড়ের একটা লোক এখানে মামলা করতে আসতে হবে তার, রাইট? কোন উপায় আছে? কোর্ট সিস্টেম পিপল ফ্রেন্ডলি? এই উত্তরটা কি হবে? অ্যাবসলিউটলি নট। কিন্তু আমি এনশিওর করছি, গ্যারান্টি দিচ্ছি থ্রু দ্য কনস্টিটিউশন, যে কনস্টিটিউশন আপহোল্ড করবে ফান্ডামেন্টাল রাইটস। আমি হিউম্যান রাইটস বাদই দিলাম, ফান্ডামেন্টাল রাইটস ইম্পসিবল। এটা কখনো সম্ভব না। কেন সম্ভব না? বাস্তবতাতে তো দেখছেন, আমরা বাংলাদেশ গত কিছু বছরে ADR কে কমপ্লায়েন্স করেছে কিছু লিগ্যাল ফ্রেমওয়ার্কের মধ্যে। আমরা সেটা জানি, আমরা দেখেছি যে লিগ্যাল এইড অর্ডিন্যান্স আছে যেটা 2015-তে হয়েছে। আবার যেটা আপনার বাংলাদেশে একটা অর্গানাইজেশন আছে, বাংলাদেশ ইন্টারন্যাশনাল আরবিট্রেশন সেন্টার, সেখানে দুইটা ডকুমেন্ট আছে, একটা হলো কোড অফ কন্ডাক্ট আর রুলস ফর মেডিয়েশন। তারা নিজেরা করেছে। মেডিয়েশনের সবচেয়ে বড় অ্যাডভান্টেজ হলো যে কোনো সময় মেডিয়েটর পার্টি আসতে পারে, যে কোনো সময় চলে যেতে পারে, নো ব্যারিয়ার্স, নো বাইন্ডিংস। তার পছন্দ হলো না, চলে যাবে, তার পছন্দ হলো, আসলো। এবং মেডিয়েটর যিনি, উনি কি জোর করে ফোর্স করে থাকতে পারবে? কোন সুযোগ আছে? কিন্তু কোর্ট সিস্টেমে আপনি পালিয়েও থাকতে পারবেন না। তাহলে এই যে সমাজ আমাকে দিল, আমি আমার মতো করে আমার সমস্যার সমাধান করার সুযোগ আছে, কিন্তু রাষ্ট্র ব্যবস্থা, যেটা আমাদের প্রথম স্লোগান, যে রাষ্ট্র ব্যবস্থা আমাকে আইন দিয়েছে কিন্তু ইমপ্লিকেশন ভেরি চ্যালেঞ্জিং, ভেরি চ্যালেঞ্জিং। আমাদের BIMF বাংলাদেশে কিছু কাজ করে দীর্ঘদিন যাবত, এটা আমি বলতে চাই, বিকজ ওয়ান কাইন্ড অফ চ্যাম্পিয়নশিপ। যে ভালো কাজ করে, ভালো খেলে, ভালো প্রমোট করে, তাকে চ্যাম্পিয়ন বলে না? BIMF হলো মেডিয়েশনের চ্যাম্পিয়ন। শত শত লোককে মেডিয়েশন ট্রেনিং করিয়েছে এবং এখন গ্রাসরুট লেভেলেও করার একটা পরিকল্পনা আছে। কেন গ্রাসরুট লেভেল? কারণ লোকাল লেভেলে পিপল, ধরুন একটা উপজেলাতে, একটা ইউনিয়নে, একটা গ্রামে, একটা পরিবারে একটা গ্যারান্টি আপনি জুডিশিয়ারি দিতে পারবে না। আমাদের বিচারক সাহেবরা আছেন, অনেকেই আমরা কোর্টের আঙ্গিনায় কাজ করি, কি দিতে পারবেন না? পিস। দুই ভাইয়ের মধ্যে ঝগড়া হলো, মা ছেলের সাথে ঝগড়া হলো, পরিবারের ঝগড়া হলো, 2 বছর পরে ডিসিশন হলো, সেই যে ঝগড়া হলো সেটা কি মিলবে? পিস থাকবে? থাকবে না। ট্রেডিশনাল সিস্টেমে কোনো সময় রিট্রিট করার সুযোগ নাই, কিন্তু মেডিয়েশনে আছে। কি এগ্রি তো? সুতরাং আমরা বাংলাদেশে যে প্র্যাকটিসগুলো চলছে সেগুলোর মধ্যে আমরা অনেকেই এখানে আইনের চর্চা করি। আমাদের কোড অফ সিভিল প্রসিডিওরে আছে, আমাদের অর্থ ঋণে আছে, আমাদের ফ্যামিলি কোর্টে আছে, অর্ডিন্যান্সে আছে, আমাদের ভিলেজ কোর্ট একটা গুরুত্বপূর্ণ বিষয় এবং অনেকে আলোচনা করবেন। আজকে ভিলেজ কোর্টটা একটা গুরুত্বপূর্ণ বিষয় আমাদের এই ওয়ার্কশপের। সেটা হলো ভিলেজ কোড যদি না থাকে অথবা থাকে তাহলে কি হবে? যদি থাকে তাহলে কি হবে, আর না থাকলে কি হবে? ভিলেজ কোড কি মেডিয়েশন? তার মানে ওটা কি স্ট্রাকচার? স্ট্রাকচার কাদের স্ট্রাকচার? যারা ওইখানে বসবাস করে, যাদের দ্বন্দ্ব হয়, তাদের বাইরের লোক। যদি কোড থাকে ওই জায়গায়, তাহলে ওইখানে যদি দেখিয়ে দেওয়া হয়, তাহলে যারা ভিকটিম তারা কি ওই জায়গাটা ছাড়া অন্য কোথাও যেতে পারবে? পারবে? যদি না যায় তাহলে আবার ক্রাইম। মেডিয়েশন কি করছে? আপনাকে মুক্ত করে দিচ্ছে। ইউ মে গো, ইউ মে নট গো। কিন্তু আমাদের যে মেডিয়েশন, আজকের যে ওয়ার্কশপ, তার একটা উদ্দেশ্য আছে। উদ্দেশ্যটা হলো, আমি আমার গ্রামে বা আমি আমার পরিবারে, আমি আমার ইউনিয়নে যেখানে আমরা বসবাস করি, সেখানে আমরা এনশিওর করব যে এই ব্যক্তিগুলো বা এই মানুষগুলো মধ্যস্থতার মধ্যে এক ধরনের দক্ষতা আছে। আপনারা খেজুরের রস খেয়েছেন? কেউ খাননি এমন আছেন? আমরা খেয়েছি, কিন্তু খেজুরের রস কাটার জন্য যে দক্ষতা, সেটা একটু স্পেশাল না? ভেরি স্পেশাল। একইভাবে সমাজে যখন দ্বন্দ্ব হয়, সেই দ্বন্দ্বগুলো আজ থেকে 5-6 হাজার বছর আগে কিভাবে নিরসন হতো? হোয়াট ওয়াজ দ্য এসেন্স অফ দ্যাট স্কিল? এক্সপেরিয়েন্স, নলেজ, empathy, sympathy, respect to the person. কিভাবে হতো? এবং বিশেষ করে ব্রিটিশ ইন্ডিয়া বা বাংলা এই ভারতে হাজার হাজার বছর আগে একটা সিস্টেম ছিল, পঞ্চায়েত। সেই পঞ্চায়েতে কারা থাকতেন? পঞ্চায়েত হেডম্যান, সিনিয়র সিটিজেন, এক্সপেরিয়েন্স, তাই না? একইভাবে যদি আমরা কনফ্লিক্টটা সলভ করতে চাই লোকাল লেভেলে, তাহলে আমাদের সেই জায়গায় এই আলোটা ছড়িয়ে দিতে হবে। এবং সেটার দায়িত্ব হলো আমরা যারা এখানে উপস্থিত হয়েছি তাদের নিতে হবে। আমাদের বাংলাদেশে কয়েকটা এনজিও আছে কমিউনিটি লেভেলে, তারা ভালো মেডিয়েশনের কাজ করে। আমাদের কলিগ আসছেন ফরিদপুর থেকে, মাদারীপুর আছেন একটা, ওখানে করে। আমাদের ব্লাস্ট আছে, করে। আইন সালিশ কেন্দ্র করে, নাগরিক উদ্যোগ করে, এরকম অনেকেই মেডিয়েশনটা করে, কিন্তু সেটা গ্রামের মধ্যে থেকে, কমিউনিটি লেভেল। আমরা চাই এই জ্ঞানটা, এই ওই যে খেজুরের রস কাটার দক্ষতাটা যেন ওই ধরনের দক্ষতাটা প্রত্যেক গ্রামেই থাকে। তাহলে হবেটা কি? যে কনফ্লিক্ট তৈরি হবে, সেই কনফ্লিক্টের লোকটা কোথায় যাবে, মানুষটা কোথায় যাবে? যাচ্ছে উনি তো বোধহয় একটু এই ব্যাপারে সমাধান দিতে পারে। যদি আমি জানি যে আমার এলাকায় একজন ডক্টর আছে, তখন উত্তম কুমার, সুচিত্রা সেনের ছবি অনেকেই দেখেছি না? এবং উত্তম কুমার নায়ক হিসেবে খুবই প্রসিদ্ধ, এবং তার একটা ক্যারেক্টার ছিল ডক্টর। সাইকেল চালিয়ে যাচ্ছে, রোগীর বাসায় যাচ্ছে, রাইট? এখন কোন ডাক্তার যায় রোগীর বাসায়? The scenario is shifted. মানুষের মতো ছিল যে আমি জ্ঞান অর্জন করব। Why? For making money. How much money does a man require? How much land does a man require? Right? Philosophical বই এগুলো রাশিয়াতে অনেক লেখকরা লিখেছেন, সেদিকে আমি যাচ্ছি না। আমি বলছি এই জিনিসটা আপনাদেরকে স্মরণ করে দিচ্ছি, আপনারা অনেক ভালো জানেন। সেটা হলো যে সমাজের যে পরিবর্তনটা হয়েছে, সম্ভবত 1773 সালে বা 83 সালে জাস্টিস এলিজা এমপে প্রধান বিচারপতি হিসাবে উইলিয়াম কোর্টে জয়েন করেছিলেন। তার আগে কিন্তু কোর্ট ছিল না, কিন্তু বিচার ছিল। কিন্তু মজার বিষয় হলো, উনিও যখন কোর্ট চালাতেন তখন মুফতিকে ডাকতেন, কাজীকে ডাকতেন। ওই এলাকায় যে কাস্টমারি প্রিন্সিপালস, কালচার যারা অ্যাকোয়ার করেছেন, অভিজ্ঞতা অর্জন করেছেন, তাদেরকে ডাকতেন। সেই কনসেপ্ট থেকেই কিন্তু জুরি শব্দটা আসছে। যে ক্রিকেট খেলা জানে না, গ্রামার জানে না, সে কি এম্পায়ার হতে পারবে? মেডিয়েটর ওই সোসাইটিতে এমন একটা জ্ঞানের চর্চা করবেন যিনি এই দ্বন্দ্বটা নিরসন করতে পারেন। এই দক্ষতাটা আমাদের অর্জন করতে হবে এবং এই দক্ষতাটা সমাজে দিয়ে দিতে হবে। বাংলাদেশে একজন প্রেসিডেন্ট ছিলেন, উনি বলতো যে বাংলাদেশে কাউকে নিরক্ষর রাখবো না। অক্ষর সাক্ষরতা অভিযান না স্বাক্ষর জ্ঞান? স্বাক্ষর কি জ্ঞান হয়? কারণ সে মনে করে এটা একটা চিহ্ন, কিন্তু সে তো জ্ঞানী। লেখাপড়া না, ইউনিভার্সিটি না গেলে, স্কুলে না গেলে কি মূর্খ হয়? শিওর। কিন্তু কিন্তু আমরা অনেক সময় বিশ্ববিদ্যালয়ে পড়াশোনা করে দেশ ছেড়ে চলে যাই, না? এবং টিচাররাও চলে যায়। আমার সময় কিন্তু আপনি হয়তো বলবেন যে আপনি তো বললেন, অনেক ভালো ভালো কথা বললেন, কিন্তু মেডিয়েশনের একটা প্রবলেম আছে। বিশেষ করে অ্যাজ এ লয়ার আমি মনে করি আই লুজ মাই মার্কেট, আই লুজ মাই মানি। কিন্তু এটা নট কারেক্ট। কেন কারেক্ট? প্লেন যখন টেক অফ করে তখন অনেক এনার্জি লাগে, যখন উঠে যায় তখন এনার্জি কম লাগে। যখন মেডিয়েটরস হবে অনেক, তখন কারা মেডিয়েটরস হবে? ইউ, মি অর সাম আদার। আমরা এখানে যারা আছি তারা সমাজে তো আমরা, আমাদের ছাড়া তো কনফ্লিক্ট রেজলিউশন করার আর কোনো মার্কেট নাই। যদি আমরা ব্র্যান্ডিং এর ভাষায় বলি, উই উইল বি দ্য ব্র্যান্ড অ্যাম্বাসেডর অফ দ্য মেডিয়েটরস। এবং যে ভালো করে, একজন মেডিয়েটরস এর সবচেয়ে বড় কোয়ালিটি হলো ভেরি মাচ ইম্পার্শিয়ালিটি। এখন আপনি যখন করছেন, ইম্পার্শিয়াল যদি না হন, আপনি যদি কারোর প্রতি একটু ঝুঁকে যান, এটা কিন্তু আপনি লুকাতে পারবেন না। কারণ এটা সোশ্যাল সায়েন্স, সাইকো সোশ্যাল ইস্যু। জেনে যাবে এই লোকটা ধনী, এই লোকটা গরিব, এই লোকটা অসৎ, এই লোকটা মেডিয়েটরের কথা বলছে কিন্তু সে মেডিয়েটর করছে না। যার কারণে এই প্রবলেমটা সলভ করার জন্য আমাদের যেটা করতে হবে, লেক অফ অ্যাওয়ারনেস, which is started today. আপনারা যারা আছেন এবং আমরা আরো হয়তো বাংলাদেশ মিডিয়েশন ফোরামের পক্ষ থেকে আরো যেখানে আমাদের যাওয়ার সুযোগ হবে আমরা যাব, আমাদের যারা আছেন। আরেকটা হলো, আমরা যে জানবো সেখানে আমরা শিখবো কোথেকে? আমাদের শেখার দরকার আছে না? শেখানোর দরকার আছে না? স্কুলিং, ট্রেনিং, ক্যাপাসিটি বিল্ডিং এই মেডিয়েশনের উপরে খুবই দরকার। লাস্টে আমি একটা বলবো, মেডিয়েশন সেলফ রিলায়েন্স, নন ভায়োলেন্স, সেলফ রিলায়েন্স। আমরা সহিংসতা করতে পারবো না। আমরা ভাই বোনের মধ্যে, পরিবারের মধ্যে ভাগাভাগি করতে পারবো, ডিভাইড করতে পারবো না। ডিভাইড হয় বলেই তো ডিসপিউট হয়, কনফ্লিক্ট হয়, প্রপার্টি নিয়ে হয়, আর একটা লাভ এন্ড অ্যাফেয়ার্স মারামারির জন্য হয়। তো এইটা যেন আমাদের মধ্যে সলভ করতে পারি। নো violence, self-reliance. এটি আমার মেসেজ। আমার হয়তো কথাগুলো একটু বিচ্ছিন্ন, কিন্তু আমার এখানে রাইট আপটা আছে, এটা আমরা আমাদের বাংলাদেশ মিডিয়েটর ফোরামে আপনারা ওয়েবসাইট আমরা দিয়ে দিব, প্রত্যেকের নাম্বার আছে, আপনারা অ্যাক্সেস পাবেন। থ্যাংক ইউ ভেরি মাচ।
Slide change and like.
Thank you, Mr. Mahbub Islam. Why we prefer area to village code? To know about this code now, I would like to request Mr. Sharif and Sanal to share his valuable speech. Mr. Sharif and Sanal, Additional District and Session Judge, Shakira.
Respected Chair, Honorable Justice Emdadul sir, respected Senior District and Justice, respected Chairman BIMF, respected Chairman Mediators Forum, all others from Mediator Lawyers Guild, respected Honorable Speakers, invited here, and the audience. Assalamu alaikum. Good afternoon. Now we have entered into the topic which has been selected for today's discussion and workshop. That is why we prefer mediation instead of ADR instead of village schools. So I will not take so much time. I will do within time. Please cooperate with me. So maybe some interest due to there is no slide change that I have to switch here and there. Don't take it otherwise. Don't think I am dancing. Okay, here it is, right? So why we prefer area instead of village schools? Who can say it? Is there anyone who can answer it? Why we prefer area instead of village schools? In place of village schools? Why? Would you please volunteer? There are some brilliant faces like Isha Hassan is there, some other guys are there, other madams are there. I have noticed them, they were very much engaged in their smartphones. I think they are smarter than me. So please would you volunteer me why we should prefer area instead of village schools? Because from morning, our friends from overseas, our distinguished speakers from here try to persuade you why we should opt for area, especially mediation. So I expect someone of you might ask me. Yes, please.
মেডিয়েশনের দুইটা ব্যাপার একসাথে না, শুধু হয়তো মেডিয়েশনের জন্য তারা সালিশ করে আসতেছে, কিন্তু অল্টারনেটিভ ডিসপিউট রেজুলেশন উইদিন দ্য সিস্টেমের মধ্যে আছে, and that is approved by many system.
Thank you very much, ma'am. Anyone else? Anybody? Oh, thank you. Thank you. Yes, please.
স্যার, আমার মনে হয় এখানে এরিয়ার মধ্যে অনেকগুলো বিষয় আছে, মেডিয়েশন, কনসিলিয়েশন, আরবিট্রেশন, কিন্তু ভিলেজ কোডের মধ্যে হচ্ছে যে স্থানীয় পর্যায়ে শুধুমাত্র তাদের হচ্ছে যে সালিশির জ্ঞানটা আছে, এছাড়া যে অন্যান্য ম্যাম বললো যে অন্যান্য আইনের জ্ঞানটাও তাদের মধ্যে নাই, থাকলেও এটা সীমিত পরিসরে, কিন্তু এরিয়াটা হচ্ছে যে একাধারে অনেকগুলো সিস্টেম নিয়ে কাজ করার কারণে এরিয়াটা বেশি প্রেফার করি।
Thank you very much. Sir, have you visited village code anytime in your life?
Yes, once a time.
Yeah,
Because I grew up in village.
Then I know this is a house full of brilliant faces. This is a house full of brilliant faces and our sir is there. May I ask a question like a fool? In Bengali, Bokar mothe ekta proshno kori. How many of you think village code is a code? Is it a code?
No.
Before that, I may answer in very few sentences. Why we prefer village code? Why we prefer area to village code? Because all over the world, why people prefer area instead of codes? That's why we prefer area instead of village code. But how many of you think village code is a code? If it is a code, I have no discussion. I may conclude. Right, sir? If it is a code, then the reasons are there. Why all over the world people prefer ADR instead of courts, then I also prefer ADR instead of village court. It is a court. But my question is that, is it a court at all?
No.
No? Who says? Please, ma'am.
সালিশ পরিষদ বিশেষ করে একটা সালিশ পরিষদ হিসেবে যখন ভিলেজ কোর্ট এটা আসে তখন বলে এটা সালিশ পরিষদ যেখানে একজন নারী থাকবে, চেয়ারম্যান থাকবে, কমিশনার থাকবে এবং দুই পক্ষে এসে ছোট ছোট
May I stop you, ma'am? Have you read the Village Code Act, Village Code Ordinance? Act in 2006, and ordinance was in 1976. Yes. Have you read or have you gone through the provisions of Village Code Act 2006? There they say a court, Grammar, right? Let's say it. Okay. So she says village court is not a court. How many of you support her? Support her? From legal background, from lawyer, do you support her? It is enacted in the Village Court Act in 2006. It is a court, right? Sir says it is a court. Let's see it. So what is the legal framework? Do you know it? The Act of 2006 and the rules 2016 and what? And guideline from the local government authorities. These are the legal frameworks. So who is the supervisory body of village courts? Supervisory body. Is it Supreme Court? Is it CJM? Is it district judge? Who? If it is a court, then Supreme Court should be the supervisory authority, sir. But village court is not being supervised our Supreme Court. Let's see. Oh, another point. Advocates are not allowed. So many, what harm the advocates have done to them? Why they have prohibited you? I don't know. You are a very brilliant faces. You are full of empathy. Our institution has done a lot of litigations for the benefit of children, for others. Like our Muslim sir has done a lot of works. You may read the precedents in the BLT and other journals. But what the harm have you done? Why they have prohibited you in the village court? Is it a court? Okay, let's see it. How does it work? Is it, okay, next, is it against the separation of power spirit and the Mazdarshan case? How many of you think so? Is it the spirit of separation of power and the spirit of the verdict of Mazdarshan case? So aren't you surprised that 19 years this act prevailed without being challenged in the Supreme Court? I am surprised a lot. Let's say another thing. During COVID, they did not stop. All the courts of the country were stopped by the circular of Supreme Court. But they did not stop, sir. So they did not think they are under any supervision. What did they do? This is from their journal. This is from the journal, and this journal is like Uchchash. They tag it, they spread that village school is functioning very well. But see their really. What did they do? They did not stop. So, ma'am said, and many of you said that it is against the separation of power because our constitution says local government bodies are part of executives. So executives are running the court. Union Parishad chairman is part of executive. How he is allowed to run the court after the verdict of Mazdarshan case, after the so-called separation? Why? Is it court? But we cannot say that, as long as the act is there, sir. So let's go. This is their supervisory authority. They report to the secretary of law, not to the Supreme Court. We don't know. We don't have any data. Sir said only 31 cases are there pending because we don't have data, and there is data manipulation. I will show that. So this is a chart, sir. I request the attention of Chairman BIMF. This data was collected. I am hiding the name of the district, and this is there from their official records. So in the first quarter, 2025, they have 82 cases pending in one district. And they started their journey with 61 cases. Now they have 82 cases there. There is also a Haque. This is what? They did not enter the cases got from the higher court, that is from season courts. The season court reports during this time, these 3 months, they have sent 66 cases to the village courts. So if you add 66, then it becomes more than 140. Data manipulation is there. So this is going on. So we think the village court should not be there because conflict of interest, chance of manipulation. Do you agree? Do you agree? চেয়ারম্যান সাহেবের প্রভাব বিস্তার করার ক্ষমতা রয়েছে। Do you agree? Conflict of interest রয়েছে। Do you agree? Okay. The chairman and other members are from there. If you see the organization, the 3 members are from Union Position. The chairman himself and 2 other members. So 3 of them, and 1 from this side, other from that side. And if they are united, they can kick out and they can total. Gola people hotta kora. The chance of appealing. You cannot appeal. We'll show that. So the philosophy for which a judge is not posted in his own district is the philosophy for which a chairman of Union Parishad should not be the chairman of the court. Because he knows everybody who chanted slogan for him in the election, who gathered in the procession, who did not gather. He knows everything. He knows the name of the person, even the name of the daughter, even the name of the wife of the litigants. So how he can be impartial? There is no chance of that. Okay, let's go. What our experts say, did he code or not? Sir, to আপনার মাইক্রোফোনটা দিতে হবে, দেখি।
স্যার মাইক্রোফোনটা হাতে নেন।
মাইক্রোফোন হাতে নেবে এটা? না এখানে কি করব? এখানে শোনা যাচ্ছে না সাউন্ডটা ও বন্ধ করা আছে। কোনটা দেখতে পারবেন? দেখান। Expert. Then he was not the chairman of this commission. Sir, then he was not the chairman of the commission, sir. It is from 6 years back. So there is speech comment of Dr. Ahmed and the UNDP activating village court project director. So and some litigants. What they say about village court? Okay, can you listen to that?
না ওইটা দিয়েছিল
Okay, how can I help? Thank you. So let's go to the another. This is the legal framework for which we shall have to say a court unless and until it is being repeated. These are the legal framework, why it is formed, how it is formed. You all may know it. I should not waste my time because my time is well, yes sir, time constraint is there. So may I proceed? Okay, we shall show. So these are the provisions, you may go. I am not wasting any time. So what are the cases there is tried? You know that offense of theft, offense of cheating, offense of criminal breach of trust, etc. from our criminal side. And recently the amendment added the pecuniary jurisdiction to 3 lakh. And another thing, the past maintenance of our sisters and mothers. What about the future maintenance? She will have to go for another litigation. How funny is this, sir? They are going to deal with the past maintenance. Their family code is there, but they are doing it. And what will happen to the future and the present? They have nothing to say. So let's see it is 7. This is the recent amendment and this is additions. So let's go it. But there are some limitations. All the cases cannot be instituted in the village court because previous conviction and time bar is there. In criminal cases, there is time bar, sir. You cannot file a case after 3 months. Okay. So time bar is there, and you cannot bring a case in the village courts where the interest of the child is there. Then the child has to go to the court at district headquarters, not to the village courts. Okay, then the harsh reality. This is the harsh reality. You cannot file a case after 30 days. 30 days only. You cannot file a case. And in case of civil matters, you cannot file a case after 60 days. These are the limitations. And here comes the provision for the lawyers. Here. Yes, section 14. Okay, I am not going to stop spend my time. So limited scope of ADR. Sir said, Mahbub Rahman said, yeah, there are ADR provisions in there. But you see, this is a mockery. Simply 15 days are there. If you mediate, it's okay. If you don't mediate, it's also okay. How there will be mediation? Who will mediate? Are they trained? Do they know the norms, the etiquettes of mediator? Perhaps the answer is No, right? Okay. So this is nothing, limited scope of there. Again, see 30, rule 30, this is the rule 30. Recently made rule in 2016. Who can remove the chairman? If you make any complaint, the chairman is being biased. I did not go for his missile procession. He is going to grab me by my neck because of his earlier vengeance. You cannot do something. The EONO, Upajala Nirbahi Officer, has been given the power to remove the chairman. It is the executive, not the judiciary. See, should he say it again court? Okay, you are not going to say it court anymore. And here is another thing. They manipulate the decision. If it is 4:1, you cannot file appeal. You cannot file appeal. If it is 3:2, you can file. If it is 4 members, you kick some on there, you give threat to someone else, alright, you will not come here. And there are 4. The decision is 3-1. You cannot file appeal. That's why I said totaling the chance of filing appeal. Totaling the chance of vengeance or grievance. You cannot. That's why I think this is another thing. So the decision of village courts are being accepted under compulsion, not in satisfaction. For the litigation, it ends the litigation, but not the confrontation of dispute, because they bear it in their mind. They were compelled by the chairman. So what mediation and ADR does, it ends the dispute. We'll see that. Okay, let's go. This is the malpractices what I have witnessed as CJM. See, dowry cases are there. Dowry cases are there. They accept that. They recording of civil suits as criminal cases because they want to give some compensation. Civil suits are being recorded as criminal cases because then you cannot file transfer case to CJ. They do the cases of getting back the wife. I want my wife back. They accept that. They frauds. They do the practice fraud I have told you. I have recorded in my laptop. I have brought my laptop here. If you challenge me, I can show you. They do manipulation in the judgment as well. So the second marriage case is a common petition to the chairman. My husband is going to marry another girl. So they accept that as well. Again, family suits for maintenance. Now it has a limited scope, past maintenance. Not following the rules, informing the court. They don't follow because I have found a lot of cases where women were accused. It is a mandatory provision. When women are accused, there should be one female member of the court. But then, so these are the things. So this is the manipulation of data I have already told. I should not waste my time. Another slide. Can I? Okay, play it.
Another slide.
এটা সাউন্ড নাই?
না এটা সাউন্ড দেওয়া যাবে না, ওইটা দিতে হবে।
ওটা কেমনে দেবো?
ভিডিওটা
হ্যাঁ, ভিডিও দিতে পারবেন না?
হ্যাঁ, অডিও একটা দিয়ে দেন।
আপনি এখানে জাস্ট এইটা স্পিকার নাই?
আচ্ছা,
জ্যাকটা দিলে তো হতো। আমি তো জানি জ্যাক দিলে হয়।
মাইক্রোফোন ব্লক কর।
ওহো, স্যার টাইম হাউ much time, sir? Have you finished? in no detail of that. Okay, you will see that. I will keep that here. You will see that. What's that? The interviews taken up by our Sohel said Sohel sir challenged that 16 years back that this court should not be allowed to run because of the theory of separation of power. Because chairmen are being elected using a symbol from the political parties. How can they be neutral? And the representative of UNDP who is working with the village code project, he said maybe we should not call it a code, we may call it otherwise anything like something like blah blah. He was not confident enough to call it code. And the ex-minister for local government, some engineer, I am not going to cite his name, he said it is not a code, it is like something like Shalish Policy. You will find it in the interview. So I am not going to narrate it there. So slide?
Yes.
Oh, okay. Sometimes don't know there. This is the example. Right. So why we should prefer mediation or ADR instead of village code? There are a lot of reasons. We may ask the question, why not? We may ask the question, why not? Because mediation gives us the opportunity to settle the dispute forever, keeping the harmony, keeping the bondage intact. While the court verdicts, whether it is village code or court of CJM, court of additional justice, even court of our highest authority, it gives a verdict. Somebody is hurt, somebody is delighted. But in mediation or in negotiation, both the parties are in win-win situation, smiling faces, right? Okay, sir.
And videos on
Video, we should not waste time. I may conclude then, if you can get time, if they allow me, then I will show the slides are there. You should not stand. So these are the reasons where our village could fall short. Potential for bias, lack of legal expertise, the lawyers not there, and the chairmen and members are not even educated up to the mark. I must say, I must confess, and you have no hesitation to admit that. You should not. Enforcement of challenges and limited procedural safeguards. So, alternative dispute resolution, modern approach. We know that. What is ADR? Negotiation, mediation, arbitration, and reconciliation. These are the approaches. So we hope and pray that there should be this one, not the earlier one, which says Khuriye cholche gram adalat. Khuriye chola gram adalat should be replaced by the modern techniques of ADR. Do you agree? May we give a clap? Thank you. Why ADR takes place in legal expertise is that skilled professionals are there, trained by BIMF or Bangladesh Mediator Guild or Mediator Forum or something like that. You will be trained. There are trained mediators and accredited mediators, and our Gaskata, Dokho, Tasha will be created here and there. So there should be skilled persons, reduced biasness because mediator don't know, and we have ethics and code of conduct, and focus on legal aspects as well. Later, tailored solutions and greater flexibility, customized processes. You may agree, you may not agree, you may opt for the options whether mediation or arbitration. Emphasis on relationship building is very important. Mediation in practice aims to preserve, improve relationship between the disputing parties, ends the dispute, conflict, and bonds the relationship. Saving time and process, saving time and resources, it can be very quicker than the court system. Lower cost, reduce burden of formal courts, privacy and party environment. And this is a ray of hope and a wake-up call. What is that? The report of our local government reform commission. Sir is there, he will elaborate that. This is a ray of hope and a wake-up call for the nation as well, sir, I must say. Because they have proposed ADR in place of village courts. They have first time said the body, we should have been, I must say, I may be under compulsion to admit that the Commission for Reform of Judiciary did not suggest, whether they have suggested it. Hats off to them. Hats up to them. They had the courage to speak up. So clap for the Reforms Commission. Thank you. Not for me. Okay. So these are the provisions they have proposed. So there should be ADR. There should be 3 judicial officers, 1 for ADR, 1 for civil courts, 1 for criminal courts at the Upazila level. Then the ADR officer or the mediation officer or the officer for ADR, he will train. He will have some men at each and every ward. They will do the mediation. If they fail, then they will come and the detail will be discussed by SAR. That's why I am not discussing that. I am closing and wrapping up there. So these are the things. That's why this interview can be shown. Can you say it? Show it, please. Last one. এটাতে করা যাবে? যাবে? দেবো? Then এটা অন করেন। সাউন্ড করেন।
সাউন্ড একটু বাড়াই দিন। আপনার পোর্টে বোধহয় প্রবলেম। পোর্ট বোধহয় পাচ্ছে না। পোর্ট পাচ্ছে। পোর্টটা পাচ্ছে।
আচ্ছা আমি দেখি। এখানে আপনার সাউন্ড নাই। আমি দেখেছি।
নিচে হাইড হয়ে গেছে।
হাইড ওটা বোধহয়
এটা
ওটা খুলে ফেলে। সবই তো বানানো আছে।
সবই বানানো আছে।
Okay, sir said that things which I have disclosed, that he is being part of executive, that is unconstitutional. Because being part of executive, he should not be allowed to do the work of juror or judicial adjudication. I think Ishrat Hassan has another class, another session. She will elaborately discuss that. Maybe I am within my time.
Conflict.
I should conclude. Okay, open the slide again. Let me conclude in a formal way. Sir's interview will be available at the YouTube as well. That's why. So, like trained mediators, we may have some trained experts for the ICT as well. Okay, sir, no problem. So, here is it. I may wrap up in conclusion. The preferred walkthrough resolution, where village courts serve a little purpose. At the grassroots level, ADR offers significant advantages in terms of expertise, fairness, flexibility, efficiency, and confidentiality. Investing in and promoting ADR mechanisms can contribute to a more effective and equitable justice system in Bangladesh. Encouraging greater awareness and utilization of ADR is crucial for the future. And gentlemen and ladies, this is now or never. The state is calling you, so raise your voice. ADR instead of village courts. Thank you so much. If you have any question, please.
আপনি যে মেসেজ দিলেন এই মেসেজ বাস্তবায়নের দায়িত্ব হচ্ছে সরকার থেকে যদি বলি তাহলে হবে না। এটা আমাদের মাননীয় সুপ্রিম কোর্ট থেকে যদি কোনোভাবে কোনো কায়দা করে যদি বাস্তবায়ন করা যায় তাহলে হবে।
Please continue.
তো আমার এই অভিজ্ঞতা কোথা থেকে এলো আমি সেটা বলতেছি। আমি 92 থেকে ফরেন এরিয়া প্রথম সালিসির উপর কাজ করি। সালিসির উপর কাজ করে আমি 96 এ আপনার ভিলেজ কোর্টের উপর কাজ শুরু করি। বাংলাদেশের প্রথম ভিলেজ কোর্টের উপর আমি ফরেনারের সঙ্গে কাজ শুরু করি। তাতে আমার যে অভিজ্ঞতা তাতে ভিলেজ কোর্ট আমাদের দেশে বাস্তবায়ন করার কোনোই সম্ভব না। এবং এটার আমি একটা বইও লিখছিলাম। তো আমি জাস্টিস সোহাল আর হাকিম সোহাল আপনার ডক্টর মিজানুর রহমান তৎকালীন বার কাউন্সিলের ভাইস প্রেসিডেন্ট এবং আমি, যেহেতু আমি ডোনারদের সাথে ভিলেজ কোর্টের কাজ করি, আমাকে ফাইনাল ভিলেজ কোর্টের ড্রাফটিং বিষয়ে আমার সাথে কথা বলতে হবে।
So would you please shorten your question, sir?
হ্যাঁ, তো আমি ওখানেও যেভাবে করা হয়েছে এরপরে যারা করতেছে বর্তমানে ওই ইউএনডিপির টাকায় ভিলেজ কোডের প্রজেক্ট চলতেছে।
ফেজ 3
সুতরাং শুধু টাকাই লস হচ্ছে, কিন্তু বাস্তবায়নের কিভাবে বাস্তবায়ন হবে সেই কাজটি হচ্ছে। এখন আমরা যতই ভিলেজ কোড বা এডিএর উপর কাজ করি না কেন, যেহেতু আমিও তো এডিএর উপর গভর্নমেন্টের পারমিশনে কাজ করছি, ভিলেজ কোডের উপর নিয়ে কাজ করছি, এটা এখন এই মহামান্য হাইকোর্ট থেকে অর্ডার ছাড়া হবে না। সুতরাং আমরা যত ওয়ার্কশপ করি কোনো কাজে আসবে না। আমরা যতই করি এই মিডিয়েশন আপনার 89A-তে যে সিভিল প্রসিডিউর যে চেঞ্জ হয়েছে সেটাও কিন্তু বাস্তবায়ন হচ্ছে না। কি করে বাস্তবায়ন হচ্ছে না? আমরা আইনজীবীরা বলি না আমার পক্ষ সালিশ করেন না।
Maybe I have got your point, sir. Let me.
তো যাই হোক, আমার এই সাজেশন থাকবে যে
Sir,
বাস্তবায়নটা
let me
কিভাবে
answer,
করা
sir,
যায়
please. Thank you, sir, for your expertise and experience and the comment, valuable comment and suggestion as well. Sir, you are the state. You, me, and all of our the states. We are the change makers. We have proved it very recently. So you cannot put the burden, shift the burden towards the court, towards the state. You take the burden. First thing. The second thing is that when we change our profession, when we cannot do better in our profession, right? There are a lot of teachers who became lawyers. There are lawyers who became teachers. Maybe I am turning to be a mediator from judge. I don't know what happens, sir. If people don't go to the court, they go to the mediators, it will flourish. So we need trained, ethical, and honest mediators. If we can show the litigants the best way, the best research, the best places, they will flock there, not to the court. They will flock to the door of mediators. They knock to the door of mediators, not to the courts. So we are doing that, and I must acknowledge that I am here because of BIMF. BIMF conducted a vigorous training for 40 hours. The judicial officers and advocates of Rola district, the very remote district, I was there and so on at that time. A long ago, sir. Right, in 2012. So it is a very remote place. BIMS conducted a training there. So I request BIMS to do it again and again to make more and more gussy for the delicious dates. Thank you so much, sir, for your comment. And we are hopeful that we shall overcome. Thank you very much.
Thank you, Mr. Short and Ms. Haque. Now we will take a break for 1 hour from 2 p.m. We will resume today's workshop.
প্রেজেন্টেশন ভিতরে ভিডিও লিংক ইউটিউব লিংক করে কানেক্ট করে যাচ্ছে অডিও কানেক্ট করছে না প্রজেক্ট হ্যাঁ সেটাই করতেছি আমি দেখি ট্রাই করি সম্ভব কিনা আমাদের তো যে লাইভ সেশন চলতেছে তো লাইভের সাথে সব কিছু দিয়ে কনফ্লিক্ট করছে আচ্ছা আচ্ছা আর সাউন্ড সিস্টেম তো কিছু ঝামেলা ছিল আপনার মনিটরে শোনা যায় এখানে শোনা যায় এই যে শোনা যাচ্ছে এখানে শোনা যাচ্ছে ওই যে শোনা যাচ্ছে মানে সাউন্ডের সাথে কানেক্ট করা হয়েছে পরে হ্যাঁ সাউন্ড ভলিউম ল শোনা যায় মানে ফুল ভলিউমে প্লে করা আমার এইগুলো দিলে আবার ওই লাইভটা পজ রাখে না আপাতত হ্যাঁ অটোমেটিক্যালি একটা স্পিকারের এটা থাকে না ওইটা হবে না কারণ আমাদের এটা ওই যে লাইভের সাথে মানে কম মাইক্রো ডিস্টেন্স হ্যাঁ ঠিক আছে লাইভটাতে পজ রাখবো লাইভটা কি পুশ রাখবো হ্যাঁ শুনে নি কন্টিনিউ রাখবো নাকি অফ করবো আবার নতুন করে লাইভে যাবো
স্ক্রিনে বাধা দিচ্ছে বারবার আনসিটের স্ক্রিন কাজ করছে না এ কী করে নেটে অনেক প্রবলেম নেট অনেক আপ ডাউন আপনার প্রতিদিন 3টে স্ক্রিন সবচেয়ে ইম্পর্টেন্ট আনসিটের সেই স্ক্রিনে বারবার
নেট চলে যাচ্ছে, নেট চলে যাচ্ছে।
সেটা করেন না
এইখান থেকে
Everyone, I requested everyone please take your lunch token. Please, I requested everyone.
এরকম সিচুয়েশন আমরাও করে নিই আজকে এরকম
মানে
আমাদেরকে এটা বলে রাখতে আমরা সব কিছু অ্যারেঞ্জ করে রাখবো।
ওইটা একটু লাগতেছে যে আমাদের নেট না থাকলে তো আমরা কানেক্ট আমার কানেক্ট না হলে আমরা কি ইস্যু না।
আগে কোনো কিছু ইনফর্ম করে দেয়, ইনফর্ম করলে আমরা
সাউন্ড
10বার চেক করতাম।
সাউন্ড নেট সব জায়গায় কমপ্লিট করছে। লাইভে তো হচ্ছে সব কিছু ইনস্ট্যান্ট না, রেকর্ডেড থাকলে আপনি এডিট করতে পারবেন, আপনার এডিটের কোনো সুবিধা এরপরে লাইভে আসবে।
এরপরে তো আরেকটা মধ্যে ইয়ে আছে, ভার্চুয়াল একটা কনফারেন্স আছে। আচ্ছা আমরা মোটামুটি সব কিছু রেডি করতেছি, আপনারা কি থাকবেন এখানে?
হ্যাঁ,
সাউন্ড টাউন্ড সব কিছু
সব ওকে করে এটা পুশ করেন।